Hello, ladies and gentlemen. Once again, my name is Mutiawa Conrad, and I'll be taking you through international law today. And specifically, we are going to be looking at the topic of immunity from jurisdiction. Again, I invite you, ladies and gentlemen, to subscribe to my channel in case you want to always receive instant updates on the latest topics in the various fields of the law. Thank you very much. Let's proceed to start with our topic today. Like I said earlier, immunity from jurisdiction. Now, from the onset, ladies and gentlemen, you should note that state immunity and diplomatic immunity are two principal exceptions to the exercise of territorial jurisdiction. So whereas we know that as a principle of law, states have powers, or they have territorial jurisdiction or powers to try any person who is within the boundary of such a nation. But however, the principle of state immunity and the principle of diplomatic immunity are the exceptions to that general rule. So that is very important to note from the very beginning. Again, state immunity, it's very important that we identify what this is, and we shall also look at diplomatic immunity by way of definition. State immunity refers to immunities enjoyed by foreign heads of state. Then, diplomatic immunity refers to the immunities enjoyed by their official representatives. That is the distinction between the two, and those are the definitions of each. Let's now proceed to look at state immunity. Okay? Generally, as we are looking at the topic of immunity from jurisdiction, just in summary, we are going to look at state immunity. We shall also look at diplomatic immunity. We shall look at the heads of state, how are they handled under international law in regards to immunity, and what are the various principles governing heads of state. We shall also look at consular relations. Okay, what does the law say about consular relations? And then lastly, we shall also look at international relations. So let's start with state immunity. Ladies and gentlemen, the principle governing state immunity is abbreviated, or is also stated in Latin under the maxim that in parem non habet imperium. Okay, that is a rule of law. And what this basically means is that all states are equal, and no state may exercise jurisdiction over another state without its consent. That is a rule under international law governing state immunity. Of course, this also extends to acts done in private capacity. So in case a head of state, okay, does certain acts in their private capacity, they are also covered under the principle of state immunity. Authority for this position, ladies and gentlemen, can be found in the case of Miguel versus Sultan of Johore, a case of 1894, Queen's Bench, Volume 1, page 149. The brief facts of this case were that in 1885, the Sultan of Johore came to England, and according to the plaintiff, who was called Miss Michelle, he took the name Albert Baker and promised to marry her. Of course, there was a dispute where he didn't, and the case ended up in court. Court held that the Sultan was entitled to immunity, even though up to the time of the suit, he has perfectly concealed the fact that he's a sovereign and has acted as a private individual. So court went on to say that whereas the Sultan had concealed and hidden the fact that he was a head of state, he still enjoyed his immunity, and that Miss Michelle could not therefore open prosecution or bring a suit against the Sultan, and that he was clearly protected under the principle of state immunity that also in fact extended to his private actions. Also, court interestingly went on to identify in that case that immunity, state immunity, can only be waived where a head of state so decides to waive it, or in case there is a suit brought against them. If they make a decision to appear in court in person, it's only then that such immunity can be waived, and it's only them that can choose to waive such immunity. Look at the case also of Parliament Belge case of 1879, volume 4 PD, page 129. In that case, it was held that the Parlement Belge, a mail packet vessel belonging to the Belgian king, was entitled to complete immunity. So again, and in fact, this decision was later on confirmed in the case of Bacchus SRL versus Servicio Nacional del Trigo, a case of 1957, volume 1, Queen's Bench, page 438. Again, this decision was confirmed because this was a case of 1879, but court has gone on to emphasize that indeed the principle is still valid. So in this case of Parlement Belge case, we are seeing that court went on, okay, to extend immunity to the packet vessel which belonged to the Belgian king. So immunity can even extend, ladies and gentlemen, state immunity can even extend to packages of a head of state, as seen in those two authorities that I have shared with you. Let's again proceed to look at another very important principle which governs state immunity, and this states that there is immunity, okay? There is immunity for jure imperi and not jure gestionis. So basically, this principle is only stating in summary that there is immunity, okay, for specifically government acts, but there is no immunity for private acts. So acts done by a state have immunity, or they are covered under state immunity. But in case a state makes or does certain actions that are of a private nature, especially where states go on to involve themselves in private business or commercial transactions, these are private acts, ladies and gentlemen, and the principle in law is well stated that jure imperi is covered by state immunity and not jure gestionis, or private acts are not covered by state immunity. That is very important to note from the onset, ladies and gentlemen. I invite you to look at the case of Empire of Iran case. This is a case of 1963, 45 ILR, page 57. In this case, the Federal Constitutional Court of the German Republic held, among others, that one, the criterion for distinguishing between sovereign and non-sovereign state activity is the nature of the state's action. So court guided to say that we shall always look at the nature of the state's action, the nature of their transactions. Also, secondly, court went on to hold that the criterion for distinguishing between sovereign and non-sovereign state activity is of the state's action. Okay, that was the guidance that was established by court. It's also very important to note, ladies and gentlemen, that this aspect of state immunity is well covered under the 1972 European Convention on State Immunity. And later on, states went on to initiate this convention in an attempt to obtain among states a uniform approach to the issue of sovereign immunity. And when you go and read under that convention, it spells out circumstances in which sovereign countries or sovereign immunity may or may not be claimed by another country against the other, or before the courts of a contracting state. And under that convention, for example, immunity may not be pleaded for contracting or contractual obligations. So a state cannot plead immunity where they are involved in contractual transactions. Also, states are also required, with certain exceptions, to give effect to judgments against them. Okay, so again, that convention lays out very clearly that principle. The ICJ addressed the issue of state immunity from civil suit of 2012. So there has been cases where court has well addressed itself on this aspect. I invite you, ladies and gentlemen, to go and look at the case of German versus Italy, ICJ 3, case of February 2012. In this case, Germany claimed that Italy had breached its sovereign immunity by, among others, one, allowing civil actions to be brought or made against Germany in Italy courts, for war crimes committed by Germany armed forces in the Second World War. That was among the many issues that was brought out in court. But also secondly, that taking measures of constraint against a German property situated in Italy, and that thirdly, declaring a Greek judgment concerning similar acts rendered against Germany enforceable. So these were the main three issues that were raised in the case of Germany versus Italy. And court went on vividly to explain and hold on those three issues as follows. One, that acts, that was on the first issue, the court guided and said that acts committed by German armed forces during the Second World War were clearly sovereign acts, and as such, they attracted state immunity. On the second issue, court went on to hold that the constrained property in question, which of course was an Italian-German cultural exchange center, was used for sovereign purposes and immunity, having not been waived, that it existed in respect of it. So court went on to say that that building and property was covered or was covered by state immunity. And also court went on to hold on the third issue that the Italian court had erred in law in declaring the Greek judgments enforceable and should have been afforded German state immunity. Okay, so that was the guidance of court, and indeed those three holdings form the basis of the law concerning state immunity, especially on the principle that I've just discussed. We now proceed to look at diplomatic immunity. Ladies and gentlemen, I invite you for you to expound your knowledge on diplomatic immunity. Please go and look at the Vienna Convention. The Vienna Convention lays down a number of fundamental principles pertaining or concerning diplomatic immunity. So go and look at it, read it in detail. But however, for purposes of our discussion today, I will highlight some of the sections, I will highlight some of the articles under that convention that will be of importance to our discussion today. Ladies and gentlemen, diplomatic immunity, as I earlier on stated, is the second exception to territorial jurisdiction. Of course, here, representatives of a foreign state are immune from the application of the host state's municipal law. So here we are saying that the law, the municipal law of a country cannot apply to those representatives of a foreign country, the so-called diplomats, okay, or even an ambassador. So that is basically the principle. It's also important to note that diplomatic relations exist only through the mutual consent of states. This is very important to note, okay? Although all independent states enjoy the capacity to establish diplomatic relations, please note that there is no right to diplomatic relations. I emphasize, there is no right to diplomatic relations. This should be noted from the onset. Ladies and gentlemen, go and look at a classic case of diplomatic immunity, which I know you can find online, and this is the case of Wanduri. Wanduri versus Association for Strengthening Agriculture in Eastern and Central Africa. This is civil suit number 266, 267, and 268 of 2016. Court held in this case, this is a very interesting judgment, that diplomats are immune from prosecution in civil and criminal matters by virtue of Article 31 of the Vienna Convention. Okay, you can go and find that case on Yuli, read it in detail. It's a very interesting case, and it will help to expand on the aspect of diplomatic immunity. Ladies and gentlemen, let's look at Article 4 of the Vienna Convention. If you have your Vienna Convention, kindly open it and look at Article 4. Article 4 of that convention provides that the consent agreement of the host state must be obtained for the proposed head of the mission. This is very important to note. Let's now proceed to look at Article 9 as well. Article 9 of the Vienna Convention allows the receiving state not to recognize a person declared persona non grata. This is very important because under the convention, it states that the receiving state may at any time, okay, and without providing reasons, inform the sending state any person in its mission is persona non grata. Persona non grata is someone that has been declared unacceptable by the receiving state. Okay, so what Article 9 is basically saying is that this state, okay, Article 9 allows the receiving state not to recognize a person whom it has declared persona non grata. The state may choose not to recognize such persons, and that is also provided for under the convention. Again, I invite you to look at Article 3. It's also of help to our discussion, which lays down the functions of a diplomatic mission. Go and look at them, which includes representing the sending state. It also includes negotiating with the government of the receiving state. It also includes, among others, ascertaining by all lawful means conditions and developments in the receiving state and reporting to the government of the sending state. Those are among other functions. It also includes promoting friendly relations between the sending state and the receiving state. So there are many functions spelled out under Article 3 for a diplomatic mission. Those are among the many. I also invite you to look at Article 3 of that convention, and it provides that in the absence of a specific agreement, the receiving state may require that the size of the mission be kept within a reasonable limit. So if there is no agreement on the specific numbers, the receiving state may require that the mission be kept within a certain figure. Again, look at Article 22, Clause 1 of the Vienna Convention. It's also authoritative, and it states that premises of a diplomatic mission are inviolable. This is a very important principle, are inviolable. These are premises currently being used for the purposes of the mission. They are inviolable, okay? They are special in a way, and they should be protected, and they should not be entered in whenever such a receiving state feels like. Look again at Article 22, Clause 2. It's also authoritative. It provides or prohibits agents of the receiving state to enter such premises without the consent of the head of the mission, and all reasonable steps must be taken to protect those premises of the mission against any intrusion or danger from any person or any disturbance of its peace or anything that violates its dignity. So kindly go and look at Article 22 in detail. Also, Article 22 further provides that the premises of the mission, their furniture and all property therein, okay, and their means of transport are immune from such, okay, requisition, attachment, or execution. So any property, okay, of that mission can be, or anything in the course of transportation, okay, is immune. You can't even attach it, okay? You can't even make an execution which emanates or results from a court judgment. You can't attach or sell property of a sovereign country, okay, or of a certain mission in your local country. Again, also look at Article 24, which provides that the archives and documents of the mission are inviolable as well at any time and wherever they may be. Okay, they are inviolable. They should be respected. They should not be trespassed with, among others. Also look at Article 25, again, of the Vienna Convention, which requires the receiving state to provide a high-level protection, higher than the ordinary aliens. Okay, it should be high-level protection, out of the ordinary, that is provided to usual citizens, and full facilities for the performance of the function of the sending mission. Okay, for example, okay, you have to give examples under international law, and these are very important and they will earn you exams in case, they will earn you some marks in case you're doing your exam. Okay. This principle for respect of inviolability for a foreign mission precluded, for example, the British police from entering premises or the mission of the Libyan government, which was known as the People's Bureau in April 1984. Even where gunshots from the premises of the People's Bureau had been fired, and in fact they had even injured one of the policemen. This was during a demonstration against Colonel Muammar Gaddafi's regime. So the British police and authorities still did not enter those premises because they respected the principle of inviolability. So this is a very fundamental principle, ladies and gentlemen, I think, which we had looked at above in the articles that I had earlier discussed. Let's also look at Article 41, Clause 3. This article provides that the premises of such a mission shall not be used in any manner incompatible with the functions of the mission. So this is also very important. The mission should not use their premises to break the law. Okay, they should not use their premises for illegal activity. Okay, so they should be kept for the functions for which they were made to execute. But again, whereas there is a principle of inviolability, but it also has exceptions. And ladies and gentlemen, let's proceed to look at the exceptions to the principle of inviolability. There are a number of exceptions, one among them being where there are threats to the host state, or the embassy in question is being used to store dangerous ammunitions or any other instruments that could be used to damage the lives or bring the hosting state in danger. A classic example is the Pakistani raid on the Iraq embassy in 1973, where it was found to have a number of ammunitions, and of course that example serves as a good exception. Again, ladies and gentlemen, remember earlier we had said that the hosting state has a duty to make sure that it provides protection to the mission and the embassy of the receiving state in its own country. Okay, and that failure actually can be illustrated by the US diplomatic and consular staff in Tehran case. This was a case of the ICJ, RIP 1979. Look at page 19 to 20. This case basically, on 4th November 1979, during a demonstration, several hundred armed individuals overran the US embassy compound in Tehran, seizing documents, archives, and 52 American nationals as hostages. The ICJ, of course, held that the Iran security personnel failed to counter the attack, and the Iranian government was found liable for not having offered enough security that was above that offered to the citizens of that country. So that is very important, ladies and gentlemen, to note. But also it's also important to note that the principle of inviolability doesn't mean extra-territorial jurisdiction. Okay? The sending state's premises are not an extension of the sending state's territory. It's only in exceptional circumstances or exceptional cases, possibly for humanitarian purposes or reasons of a severe nature, will a state grant asylum to an individual within its own embassy. Okay, it's only in exceptional circumstances. So having an embassy, okay, in a foreign country does not mean that it's an extension, okay, of your land, okay, or of your authority in that country. No, okay. And we are saying that the exceptional case here, where someone can be given asylum, okay, in the embassy of that country in another country, is only maybe probably on humanitarian grounds, and that this is even so in exceptional circumstances. And we go on to give a classic example that since 2012 and up to 2019, in fact, up to about 2018, and I think you should cross-check and see if it is still the case. But from 2012 up to about December 6th, 2018, it was the case indeed that Julian Assange, the founder of WikiLeaks, an internet site which all of you are very familiar with, has enjoyed diplomatic asylum in the Ecuadorian embassy in London, actually for over 6 years now, avoiding extradition to Sweden to face charges of sexual assault. Of course, Assange alleges that if he's extradited to Sweden, then he will be further transferred back to the USA, where he will face a number of charges that the American government had actually put on him. And he has been in that embassy for quite some time. So, but however, we are saying that this is only done in exceptional circumstances or maybe on humanitarian grounds. Let's proceed to look at Article 27, Clause 3. This article requires the receiving state to allow and protect free commission by the mission for all official purposes and the diplomatic bag. This is very, very important, okay? It's very, very important. The principle of protecting or the duty of protecting what we call the diplomatic bag, which must be clearly marked as such. So the diplomatic bag is simply the bag, or it's simply where a state sends some form of documents or any communications back to its home country. Such communications of that mission are supposed to be protected. Of course, they should be marked. Okay, it should be marked as a diplomatic bag because it has vital information, probably such as communications. It can even have intelligence reports, or it can have certain items. That diplomatic bag is not supposed to be checked, but however, it should be marked very clearly as a diplomatic bag so that taxing authorities or any other organs of the country from which it is emanating should not be able to check it. The aspect of labeling it is really very important, and the absence of visible external marks from such a diplomatic bag were used in the attempted abduction from the UK of Mr. Diko. So there was a gentleman called Mr. Diko who they attempted to abduct from the UK. He was an ex-government minister of Nigeria, but however, when they tried to abduct him, they tried to take him through the diplomatic bag, and the authorities checked it, and of course, the dispute in court was that the diplomatic bag could not be checked. But however, court went on to hold that the diplomatic, whereas the principle was true, but the diplomatic bag was not marked, and that as such, authorities could not have known or thought that indeed it was a diplomatic bag. And court went on to say that the opening by the UK customs official of the container in question kept their actions within bounds of the convention because it was not marked, and therefore the authorities could not have known. Let's also proceed to look at Article 29 of the same convention. This provides that the person of a diplomatic agent is inviolable and he is not liable to arrest or detention. He must be treated with respect and prevent an attack on his person and freedom of dignity. In fact, under Article 1E, a diplomatic agent is the head of the mission or a member of the diplomatic staff of the mission. So again, we are seeing under Article 29 that the person, okay, of a diplomatic agent should be treated with respect at all particular times. It's also important to note that he is also immune from criminal jurisdiction of the receiving state. This is very important. But again, however, nevertheless, there are a number of examples that can be given or made where such diplomats have in fact been charged. A classic example is the case in 1987. The USA became the first country in the world to indict an ambassador prior to the termination of official accreditation. This was after there was a car accident in the USA, and Ambassador Abysnistos was, of course, respectfully recalled by Papua New Guinea, which was the country from where he came from, on 7th February 1987. And his accreditation to the USA ceased as of 24th February. So this is another example to show where the USA had in fact gone on to prosecute such a diplomat. The other aspect to also note is that the diplomatic agent is also immune from the receiving state's civil and administrative jurisdiction. However, there are some exceptions, okay? There are some exceptions. The first exception, ladies and gentlemen, are actions relating to private immovable property situated in the territory of the receiving state. Okay? So this is the exception, unless held on behalf of the sending state. Okay? The second exception is an action relating to succession in which the diplomatic agent is involved as an executor, an administrator, a heir, or a legatee as a private person in his capacity. So under these circumstances, he will not be subject to immunity. The third exception also is an action relating to any professional or commercial activity exercised by the diplomatic agent in the receiving state out of his official functions. So actions that he does in his professional or commercial activity are not subject to immunity, and as such he can be charged for those actions. And of course, in those three circumstances, then immunity from jurisdiction is not available. So those are the three exceptions where someone will be charged if they're a diplomat or an ambassador. It's also important to note that this immunity does not stop with these ambassadors or diplomats. It is also extended to the family members of that diplomat. Normally, the spouse and children under the age of 18. Okay, so they are also immune. If they are not nationals of the host state, okay, please go and look at Article 37. Okay, that is if they are not nationals of the host state. But if they are nationals of the host state, then they will not be subject to they will be subject to the laws of that country. That's very, very important to note. Go and look at Article 37 of the Vienna Convention. Also look at Article 32, Clause 1, which provides that the sending state can waive its right to immunity. So the state that sends the ambassador or that sends the diplomat can choose to waive that immunity. And where such immunity is waived, then the same will be prosecuted, okay, in the courts of law of the hosting state. Article 32, Clause 2 also provides that the waiver must be express. Okay, so if the immunity is going to be waived by the sending state, it must be express. Okay, it should not be implied. This is very important to note. Again, look also at Article 32, Clause 3, which provides that if a diplomatic agent or other person enjoying immunity initiates proceedings, they are then precluded from claiming immunity from jurisdiction in respect of any counterclaim which is connected with the principal claim. This is very important to note, okay? And in fact, I think this can also serve as an exception to the general rule which we had earlier stated, that they have immunity. So we are saying that in these circumstances under Article 32, Clause 3, immunity would not apply. Also look at Article 37, Clause 2. It's also authoritative. This protects or gives criminal immunity to the administration and territorial staff, the administrative and territorial, the administrative and technical staff, if non-nationals of the host state. Okay, this is very, very important. So meaning that even those administrative and technical staff that are working within or working with those diplomats, okay, they also have immunity. For example, archivists, okay, clerical and secretarial staff, okay, those also have immunity. Or even kitchen staff, okay, they are also immune. That is if they are not nationals. But where they are nationals, they will be subject to the laws of the country. And that is specifically provided for under Article 37, Clause 2. But their immunity from civil and administrative jurisdiction extends only to acts performed in the fulfillment of their duties. Okay, that's also very important to note. So these stuff that we are talking about, their immunity is only as far as the fulfillment of their duties. So should they wander, okay, or veer off the ordinary duties that they were contracted to do, then we shall prosecute them under national law. That is very important to note. A diplomat who is recalled or declared a persona non grata, of course, is allowed a period of grace during which his or her family, or during which his or her immunity continues. If he doesn't live within that time, then he can be held liable for private acts committed. So we are saying that in circumstances where someone is declared persona non grata, they should be allowed reasonable time to ensure that they move out of the country and go home. But in case that reasonable time elapses, then they will be held liable for the actions that they commit in their private capacity. Also look at Article 34. Okay, look at Article 34. Article 34, in fact, exempts diplomatic agents from paying tax. So, ladies and gentlemen, go and look at that convention in detail. It establishes a number of important principles that you must look at and appreciate. It has so many, but I've been able to pick for you some of the most important or some of the most pronounced. But go on and read it. There are other principles that it establishes. Let's now proceed to look at heads of state. It's very important to note, and I think let's start by looking at the principle that was laid out in the case of R versus Bow Street Metropolitan Spindeshari Magistrate Ex parte Pinochet Ugarte number 2, case of 2001, SC volume 1, look at page 119. This case, as you may all remember, involved General Pinochet, the dictator and former president of Chile, and the House of Lords on 25th November 1988 held, among others, and indeed these are the principles that will guide us on aspects of the heads of states and their actions as concerning immunity. Among others, court held that a former head of state could only and only be immune for acts which fail within his functions as a head of state, and that although it remains unresolved as to which acts may be categorized as official and those which may be deemed personal. So this has still stayed unresolved, and there is no known case law to me that has tried to differentiate which actions are personal while the president acts in his official capacity, and that which actions indeed are official. Of course, this is a question of fact, and the court will look at every case in its individual capacity. Court also went on to hold in that case that an individual could not claim immunity, nor could a state, in respect of acts which are prohibited by international convention and to which the state concerned is a contracting party of the said convention. So this is also a very important principle that was laid out by court. The House of Lords therefore ruled that a former head of state is not entitled to immunity for such actions as torture. Okay, so a head of state does not have immunity for actions that include torture, for actions such as hostage taking and crimes against humanity committed while he was in his office. Accordingly, accordingly, Chile could not claim immunity for liability after having signed and ratified the 1984 Convention Against Torture. So, ladies and gentlemen, this is very important. A head of state that commits crimes against humanity, that involves himself in aspects and actions of torture and hostage taking, cannot claim immunity. That is the principle that was laid out by the House of Lords in the case of General Pinochet that I earlier just stated. But also it's notable to state, or it's notable that heads of state do not enjoy immunity before the International Criminal Court. This is very, very important. Article 27 of the Rome Statute of the ICC clearly lays out that. So these will not enjoy immunity while they are before the International Criminal Court. Okay, and authority has been given under Article 27 of the Rome Statute. Another example is the arrest warrant issued by the ICC in respect of Omar el-Bashir, the president of Sudan. You remember recently that the International Criminal Court issued a warrant, and that should serve an example to what I just earlier stated. Also importantly, these heads of state do not enjoy immunity under international criminal tribunals. That's also very important to note, that immunity under international tribunals is not held by these heads of state. For example, the prosecution before the ICTY of former president of Serbia. So the former president of Serbia was prosecuted under that international criminal tribunal known as the ICTY. That was Slobodan Milosevic. Okay, so he was prosecuted. Also in 2004, the special court president of Liberia could not invoke his head of state immunity before the court. Okay, so these are a number of examples given to you to demonstrate that immunity cannot be raised by heads of state in these circumstances. Also in 2015, in 2015, the trial of former president of Chad, Habré Hissène, started before the extraordinary African chambers of the African Union in Senegal. These are three examples that have been given to you where heads of states have been prosecuted and they could not raise immunity in such circumstances. So even state immunity has exceptions, and these are the exceptions where heads of state will be clearly prosecuted in these 3 to 4 situations that I have identified to you. Ladies and gentlemen, let's proceed now to look at consular relations. What does international law say about immunity of consular relations? These consuls are representative. The consuls represent their state in another state with the consent of the latter. These are concerned not with political affairs, but rather with administrative issues, e.g. the issue of visas. They give various forms of assistance to members or nationals of the sending state in the receiving state. Those are the so-called the consuls. Look at Article 36 of the Vienna Convention on Consular Relations. It lays them, it goes in detail, okay? That is the Vienna Conventions of 1963. It gives consular relations the right to access and communicate with the nationals who have been detained in another country. So they have these powers. They can establish communications with their citizens that have been detained in such a country, and their main issue really is administrative, and it concerns a number of aspects such as issuing visas and giving the various forms of assistances to their citizens that are in other countries. Ladies and gentlemen, look at the case of German versus USA of 1998. This looks at specifically the failure of the consular service to to do its work. And of course, a case had been initiated. So the facts in German versus USA, a case of 1998, ILM 1069, the case of 2001, where that the ICJ in 2001 held that the US was in breach of its obligations under Article 36, Clause 1 of the Vienna Convention, in that the USA had informed the Legrand brothers of their rights. Actually, the USA had not informed the Legrand brothers of their rights under Article 36 without delay. So, ladies and gentlemen, let's proceed to look at another important principle governing consular relations. And this is that consular relations, unlike diplomatic relations between states, have been largely governed by bipartite agreements. So this is very important to note. Also that consular immunities, unlike diplomatic immunities, may not be presumed, but must be shown to either derive from the 1963 Convention or from a bipartite agreement. So this is very important for you to note. Also important to note is that consular premises resemble those accorded to diplomatic agents and diplomatic missions. However, they are more limited in their scope. So that's very important to note. I also invite you, ladies and gentlemen, to go once again and read Article 41, Clause 1 of the Convention, and also Article 41, Clause 3. These are really very important for you to get more knowledge on that aspect. Let's now proceed to look at our last element, which is international organizations. So international organizations and immunity, it's important to know again that these international organizations such as UN, among others, they enjoy immunities and privileges necessary for the fulfillment of their obligations and their purposes. For example, immunity from legal process, they have that immunity, and you cannot sue such international organizations. Financial controls, taxes, and you also cannot sue them for execution of their duties. These are provided for in the constituent charter of the organization and supplementary agreements adhered to by members of the organization. For example, the General Convention on the Privileges and Immunities of the United Nations in 1946, which gives immunity from legal process to inter alia, or among others, the property and assets of the United Nations, unless such immunity is waived, as well as immunity from criminal jurisdiction for its representatives. So again, ladies and gentlemen, for purposes of international organizations and their immunity, I invite you to go and look at the case of Wandai versus Association for Strengthening Agriculture in Eastern and Central Africa. This is civil suit number 266, 267 and 268 of 2016. Look at it on the principle of immunity and international organization. Specifically, I look at the judgment of Justice Christopher Madrama Izama. Ladies and gentlemen, thank you very much for moving together with me today. Again, in case you want to have more of these videos, do not forget to subscribe to my channel. And in case you find them useful, you'll be able to receive updates. Thank you very much and have a lovely day.